If I asked most people whether their will controls everything they own, they would say yes with great confidence, and they would be wrong. Not slightly wrong, fundamentally wrong. That is the first thing I want burned into your mind, because once you understand it, estate planning stops feeling mysterious and starts feeling mechanical. That is the mother line. Your assets do not move based on what you meant. They move based on legal structure. That is the whole game. At death, the law does not gather your loved ones in a room and ask what would feel fair. It does not ask what you once said over dinner. It does not ask what your family assumes you would have wanted. The law asks a much colder set of questions. How was the asset titled? Was there a beneficiary designation? Was there a controlling trust? If the answer is yes to one of those, the paperwork usually wins before your will ever gets a chance to speak. That is why so many families end up shocked. They thought they had an intention problem. What they really had was a structure problem. Most estate confusion begins because people imagine a will as some master command document floating above everything else. It feels intuitive. You sign a will that says who gets what. Therefore, a will is not a universal remote control for your balance sheet. It is a narrow document with a very specific jurisdiction. It controls probate assets. That is all. That one sentence can save people years of confusion, because once you understand what falls outside probate, you immediately understand why so many outcomes people call surprising were actually completely predictable from the start. Take a retirement account with a named beneficiary that does not wait around to see what your will says. The contract controls. Take a life insurance policy with a named beneficiary. Again, the contract controls. Take a house owned jointly with rights of survivorship. The title controls. Take a joint bank account with survivorship. The title controls there too. And if your will says something else, the will does not swoop in and override the contract or title structure, because the legal system was never designed to operate that way. That is the first mechanism I want you to understand. I call it the paperwork hierarchy. People think there is one estate plan. There is not. There is a stack. Contract sits in one bucket. Title sits in another. Probate sits in the third. The asset moves according to the bucket it lives in, not according to your emotional ranking of what should matter most. That is why estate planning is not mainly about writing down desires. It is about putting assets into the correct legal buckets while you are still alive. The source document explains this very well. Assets move at death in three ways: by contract, by title, or by probate. That is the framework that makes everything else easier. Because once you know those three roads, you stop asking fuzzy questions like, do I need a will or a trust? And start asking much sharper ones: which assets already move by beneficiary form? Which assets already move by title? Which assets are still exposed to probate because they are sitting naked in my own name? That is the adult conversation. Now let us talk about the will, because I do not want people leaving here with the wrong impression. A will matters. It matters a great deal. But it matters correctly only when you understand what it actually does. A will is a revocable document that has no legal power while you are alive. It does not control your assets during life. It does not save you if you become incapacitated. It does not avoid probate. In fact, it is the document that helps begin probate. When you die, the will gets submitted to court, and the court uses it to supervise the transfer of whatever probate assets remain. That is a perfectly useful role, but it is not a magical role. A will can name an executor. A will can direct who receives probate assets. And most importantly, a will can name guardians for minor children. That last part is not optional if you have children. I do not care how elegant your trust is. I do not care how many beneficiary forms you filled out. If you have minor children, you need a will. Guardianship lives there. That is non-negotiable. But beyond those powers, the will has limits people need to respect. It cannot override beneficiary designations. It cannot override joint ownership. It cannot avoid probate. It does not reduce estate taxes simply by existing. It does not protect assets from creditors simply by existing. That is why I dislike how casually people talk about just having a will as though that ends the planning conversation. Having a will is not the finish line. Sometimes it is the foundation, sometimes it is not enough. And that brings us to trusts, which people either romanticize or misunderstand. A trust is not magic either. A trust is a legal relationship. That phrase matters because it clarifies the purpose. A trust separates legal control from beneficial enjoyment. One person or institution manages the asset. Another benefits from it. That separation is what allows timing, continuity, and control over how assets are used. That is why trusts exist. Not to sound sophisticated, to solve specific structural problems. Now, most families asking about trusts are really asking about revocable living trusts. So let us stay there. A revocable living trust is created during your lifetime. While you are alive and competent, you often remain in control. You can serve as your own trustee. You can amend it, you can revoke it, you can buy and sell assets, you can live normally. The trust does not turn you into a guest in your own life. That is important to understand. What it does do, if built and funded properly, is create a structure that can continue operating during incapacity and after death without requiring everything to pass through the same public court, supervised probate pipeline. That is its real power. And the source document gets this exactly right. A trust can avoid probate only if it is properly funded. That sentence deserves much more attention than most people give it. Because families love documents, documents feel productive. The binder arrives, the signature is done, the lawyer was paid, everybody feels responsible. Then 5 years later, half the major assets are still titled personally. The trust sits there empty or half empty, and everyone acts surprised when probate still appears. That is not the trust failing. That is the funding failing. This is the second mechanism. I call it the empty vessel trap. A trust without assets inside it is like a moving truck parked in the driveway that no one ever loaded. It exists. It may even be expensive, but it is not carrying anything. That is why I always say the paper is not the plan. The funding is the plan. If the house is not retitled, if the brokerage account is not connected correctly, if the bank account remains outside, if the trust is not named or fed where appropriate, then what exactly did the family think would happen? This is where so much disappointment is born. Not because trusts are weak, because people confuse drafting with implementation. Now, if a revocable living trust is funded properly, it offers three things that matter a great deal. Continuity during life, privacy at death, avoidance of probate for the assets inside it. That is a powerful trio. Continuity during life is the part I think people still underestimate. Death planning gets all the attention because it sounds dramatic, but incapacity may be the more common and more chaotic threat. Stroke, dementia, illness, a long period where someone is alive but not functionally able to manage things. That is where a funded trust can be one of the most humane documents in the whole estate plan, because the successor trustee can step in and act. Not beg the court for permission. Not sit in administrative limbo. Not wait while the family is already hurting. Just act. That matters. A power of attorney matters too. And every adult should have one, but powers of attorney are not perfect. Financial institutions can scrutinize them, delay on them, question them, or make the process unpleasant. A trust-owned asset with a successor trustee creates a different pathway. The structure already exists. The seat is already there. Someone new simply sits in it. That is a much smoother handoff. This is the third mechanism. I call it the continuity premium. People often think of estate planning as a death issue. Much of its real value is actually in life's interruptions. The family does not need help only after you are gone. It often needs help if you are here but unable to function. That is where trusts shine. And then there is privacy. Probate is generally public. Not every family cares. Some should, some do not, but the point is not whether privacy is emotionally attractive. The point is that privacy can reduce noise, conflict, and unnecessary visibility around family wealth. A trust-administered estate usually keeps more of that process out of the public courtroom record. Again, not magic, just structure. Now let me say something I wish more people understood. A revocable trust is not a tax strategy simply because it is a trust. As long as you retain control, the IRS generally still treats the assets as yours. That means no automatic estate, tax miracle, no automatic creditor shield, no automatic disappearance of the property from your estate. control and taxation are linked. That is the fourth mechanism. I call it the control price. The reason a revocable trust is convenient is the same reason it usually does not create those deeper tax and asset protection benefits. You still control it, you still enjoy it, you can still change it. That is exactly why the tax law continues to see the assets as yours. People hear the word trust and imagine fortress level protection. Sometimes that exists. Usually that belongs to a different category. Irrevocable trusts are where you start entering more advanced territory, because that is where control is actually surrendered in exchange for different potential benefits. Estate tax reduction, asset protection, Medicaid planning, and more complex wealth transfer strategies. Fine. Those can be extremely valuable in the right situation, but they are not casual tools, and they are not what most ordinary families are actually choosing between. Most ordinary families are making a much simpler decision: will only or will plus revocable living trust. That is really the crossroads for most people, and the right answer depends less on ideology than on friction. How painful is probate where you live? How much privacy do you want? Do you own real estate in multiple states? Do you care deeply about incapacity continuity? Do you have a blended family? Do you need staggered distributions? Do you want assets held rather than dumped outright on a young beneficiary? Do you have minor children? Those are the questions that matter. This is why I dislike the internet's tendency to turn estate planning into slogans. Everyone needs a trust. Wrong. A will is enough for everyone. Also wrong. Trusts avoid taxes. Usually misleading. Wills control everything. Flatly false. The point is not to memorize slogans. The point is to understand the structure well enough that your documents fit your actual life. That is the fifth mechanism. I call it structure fit. The best estate plan is not the most complicated one. It is the one where the structure actually solves your real problems and does not pretend to solve problems. It was never built to handle. A straightforward family with modest assets, aligned beneficiaries, and little complexity may be perfectly well served by a will, a durable power of attorney, healthcare directives, and properly updated beneficiary designations. That can be a strong plan. A blended family with real estate in multiple states, privacy concerns, children from prior marriages, and fears around incapacity may need a revocable living trust and a pour-over will and all the supporting incapacity documents. That can also be a strong plan. The point is not whether one sounds fancier. The point is whether the legal machinery matches the real life it is supposed to carry. Now I want to come back to one of the most expensive misunderstandings in the entire document. My will says it, so that is what happens. No. If the life insurance names your sibling and the will names your children, the policy usually goes to the sibling. If the house is jointly owned with survivorship and the will says your share should go elsewhere, the house usually follows title. This is not the court being unfair. This is the court following the structure that controlled that category of asset. That is why I say intention is weak by itself. Paperwork placement is stronger. This is the sixth mechanism. I call it the intention failure. People love to talk about what they want. The legal system cares where they put the asset. That is the difference between estate planning as a feeling and estate planning as a discipline. You do not win this game by being sincere. You win it by aligning title, contracts, trusts, and documents. So the machine has no room to misunderstand you later. That is the real work. And if you do not do that work, then the family is left to sort through the mismatch while grieving. That is one of the cruelest gifts a person can leave behind. Now let us talk about children one more time, because this is where the trust versus will debate gets emotionally important. If you have minor children, the correct answer is not, I have a trust, so I do not need a will. Wrong. You still need a will. Guardianship nomination lives there. A trust can hold and manage money for children beautifully. It can phase distributions. It can make sure a teenager does not inherit like a lottery winner. It can allow support for health, education maintenance, and support under rules you choose. That is wonderful. But the will names who raises the child, different job, different document. It is often not will or trust. It is both. And that is where mature planning begins. So here is where I come down. Your will does not control everything. Legal structure does. Beneficiary forms beat wishes, titles beat wishes, probate catches. What is left? A will directs the probate bucket. A revocable trust can keep properly funded assets out of probate, offer continuity during incapacity, and preserve privacy in administration. It does not become a tax miracle just because it is called a trust. An irrevocable trust is a different animal entirely. And if you have minor children, you need a will no matter how elegant the rest of your plan looks. That is the honest answer. Not because complexity is fun. Because families suffer when they confuse good intentions with legal control. In the end, estate planning is not really about death documents. It is about control, who has it now, who gets it later, how it changes, and what legal rails the assets are actually riding on when you are no longer here to explain yourself. That is the whole thing. And once you understand that, you stop asking whether a will or trust sounds better. You start asking the only question that matters. Where does each asset sit today? And is that legal structure truly capable of producing the outcome I think I have already planned for? That is the question that protects families. Everything else is mostly vocabulary.